Professor Marianne from our hen house, her knowledge overflows. Legislation from cat to pig to mouse, she knows all of those. Critter defenders from across the globe share their stories first to last. So welcome to what we now know as the Animal Law Podcast. It's the Animal Law Podcast.
Welcome to the Animal Law Podcast. I'm so excited to be here. I'm so excited that we're doing an Animal Law Podcast here at our hen house. I'm so excited about our first guest, Steve Wise, who will be joining us in a few moments. And I hope you're excited too. I hope there are some lawyers out there who are listening and that maybe some of the stuff we do here on the Animal Law Podcast can give people ideas, just be a forum for people who are doing some really amazing cutting-edge work. But I hope there's a lot of non-lawyers out there too, because I know a lot of people are really interested in animal law, and which includes, of course, ways in which the law is protecting animals, and too often ways in which the law is not protecting animals. I got asked the question the other day. It's kind of the lawyer's equivalent of being asked, where do you get your protein? It's the question you get asked constantly, and it's basically animal law. What's animal law? You mean like his one suggestion for the possibility of where there might be something called animal law was about research, and people don't realize that animal law is not just about the laws that protect or purport to protect or too often fail to protect animals, like the Animal Welfare Act, which does concern some animals who are used in research, or animal cruelty laws, or a few other laws that are basically meant to protect animals. But even more so, it concerns so many areas of the law that touch animals, and virtually every area of the law, of course, touches animals, from estate law in figuring out how to protect your animal when you die, to First Amendment law. Think of the Animal Enterprise Terrorism Act and laws affecting activists and every possible area of law in between. So we have a lot to talk about, and it's all pretty cool. And I'm hoping to be able to get into the weeds a little bit more than we're able to do on the regular Our Hen House podcast, and really get some of the details and hopefully inspire people. And there's a lot of people doing inspiring work when it comes to animal law. And, you know, there's a lot going on, and one of the areas that I've always thought was one of the most important areas in animal law is consumer protection law, and all of a sudden that does seem to be lighting up. And one of the cases that I noticed in the past few weeks is this Mercy for Animals action against the American Humane Association. And I don't know whether, like me, you're not that familiar with the American Humane Association. You probably are, but it's always been one of those animal organizations that I thought I was not really on board with, but you know, maybe doing some stuff I didn't agree with, but you know, doing other stuff, and I kind of ignored them. And then, but you know, I knew that they did the movie stuff, you know, certifying movies as no animals were harmed. And I knew that a lot of people were saying there were serious problems with that, both in history, but continuing to be serious problems with that. And then the Hollywood Reporter did a huge expose talking about what an incredibly bad job they were doing. So that's always been a problem. But I kind of never realized all of this work they're doing in humane certification of factory farms. It's kind of unbelievable. And Mercy for Animals, one of their latest investigations, has kind of ripped the lid off of it. And American Humane is just out there certifying all sorts of just the worst factory farms and allowing them to put a label on, you know, saying that they're American Humane certified, which is going to imply to people that, you know, they're doing a good job. And they recently did Mercy for Animals recently did this undercover investigation at Foster Farms, which of course is huge factory farm a chicken outfit, and has millions of chickens, and you know, found the usual horrors of I watched the footage. I don't always make myself watch footage, but, you know, I was going to be talking about it, so I forced myself to. Just hideous stuff. You've seen it all before. The slaughter line has workers who just are handling millions and millions of chickens, but they punch them, they slam them into shackles. Some of it is work-related, some of it is gratuitous, but a lot of it is just what they have to do in order to get the job done, which is horrifying for the chickens. It's just brutal brutal cruelty. And the baby chicks back out of the slaughterhouse and back to the quote-unquote farm, which is what they call them, throwing the baby chicks all over the place, and loads of birds being scalded in hot water to remove their feathers without having been stunned or killed. And just, I don't have to keep going. You know it all. It's just classic foster farms. And apparently, American Humane is working with foster farms and other huge factory farm facilities like Butterball, Hillendale Farms, same kind of brutal activity, and just allowing them to call themselves American Humane Certified. What the hell is going on with these people? What do they think they are, calling themselves humane? I'm just so outraged. It's one thing when the industry does it. It's even another, like a little less expected, but when you have these outfits like Certified Humane, which are these third-party certification groups, which have standards. They're not strong, but they are standards that go well beyond standard factory farming. But then a group that purports to be an animal protection organization actually certifying some of the worst of factory farming. I am so furious. Like, they must be getting so much money for this. And I'm so glad to see Mercy for Animals take them on. Bob Barker narrated the video. We all love Bob, and really slammed into American Humane. I looked a bit on their website. Foster Farms, of course, has this big feature on their website talking about how, I swear to God, this is from Foster Farms claims on its website. American Humane Certified standards were built on the internationally accepted values of the 5 freedoms: freedom from hunger and thirst, freedom from discomfort. Are they kidding? Oh my God. Freedom from pain, injury, disease. Freedom to express normal behaviors. Freedom from fear and distress. This is outrageous. That's on Foster Farms' website. That American Humane's website is just as loathsome. And they're talking about how committed they are to farm animal welfare. And it's the president of American Humane who wrote this column saying that the animal ag industry needs to reclaim the word humane. It's just exactly what the animal ag industry did with the word welfare. Took it over and said, we're the ones who are paying attention to welfare. All these animal rights activists just don't think animals should be used for food in any case, which may be true, but it doesn't mean that the word welfare doesn't mean anything, and it doesn't mean that the word humane doesn't mean anything. It means something. It means something to people, and that's why I'm so glad to see that Mercy for Animals is taking some legal action. At the moment, they filed a complaint with the FTC that this nonsense violates the FTC Act, which is, of course, is federal law protecting consumers from false advertising and other fraudulent activity. And unfortunately, you can't sue people under the FTC Act. Only the federal government can act under it. You can file a complaint with them, and that's what Mercy for Animals has done. And let's hope that it is successful. Unfortunately, of course, they can sit on this complaint for as long as they want. If there isn't somebody on the inside who's particularly concerned, I'm not sure how much will happen here. We'll have to do a wait and see. I know when Compassion Over Killing years ago filed a complaint with the FTC, they actually went to the Better Business Bureau first, and that's one route you can take. That they were complaining when United Egg Producers was putting that big welfare approved check mark on their egg cartons, and Compassion Over Killing first went to the Better Business Bureau, got the Better Business Bureau to agree with them, and then the Better Business Bureau brought the action to the FTC, which is kind of a standard procedure. And I think we can safely assume that the FTC is more likely to pay attention to the Better Business Bureau than to an animal rights organization. But who knows? Who knows? Something may come of this claim that Mercy for Animals has filed, and it I mean, this is an outrage for some organization that purports to be an animal welfare organization or an animal protection organization to put these lies out there to consumers, deceiving consumers into thinking that these chickens were treated properly. Just take a look at the video and you think if it deserves any kind of certification. Even Consumer Reports has talked about the certifications from American Humane as being far below what a consumer would consider to be appropriate. I'm so furious. It makes me so angry, which is a good reason for why we should be listening to our first guest today. Animal law runs the gamut, and the kind of thing I've just been talking about, an FTC claim against a factory farm for making false claims, is at one maybe not end of the spectrum, but one branch of animal law. Another branch is, of course, the kind of work that Steve Wise is doing at the Non-Human Rights Project, which is completely amazing, but goes to the very core issues of the fundamental rights of animals and what animals are entitled to under the most ancient precepts of what we consider fair and just in the world. And I can't wait to talk to him. Welcome to the Animal Law Podcast, Steve.
Thank you for inviting me.
I'm so excited to have you here. I'm so excited to be starting this podcast. And I couldn't wish for a better first guest than Stephen Wise, who has been doing this for a long time and is doing some of the most cutting edge work in animal law, and really has been having a remarkable past year, I have to say. You've started the long-awaited process of bringing lawsuits or more specifically, petitions for writs of habeas corpus on behalf of confined non-human animals. It couldn't be more exciting time to be speaking to you. So far, we haven't had successes, but every single decision has been fascinating in a new and different way. But before we talk about the specific cases, I'd like to just get a little background on habeas corpus. Everybody's familiar with habeas corpus, but not everybody knows its history or its place in the common law. And can you briefly expand on that before we start talking about the cases?
Sure. Habeas corpus is an ancient remedy. Probably goes back 700 or 800 years. When it began, it didn't look like it does now, but over the centuries, it evolved. So by the end of the 17th century, it was starting to look a lot like it is now. And indeed, part of the Glorious Revolution of 1679 had the Parliament enact the so-called Great Writ, which was the statutory version of habeas corpus, which really supplemented the common law version. And the most important thing for our purposes would be that the common law version allows a writ of habeas corpus to be issued when a private person is detaining someone, while the Great Writ focuses on public. So one of the things that the Non-Human Rights Project was doing when it was trying to figure out where it was going to file our lawsuits was to look at whether a state had a statutory writ of habeas corpus that was patterned on the Great Writ of 1679, or whether it still used the common law writ of habeas corpus, or whether it used both. And one of the reasons we chose the state of New York was because it has a very vibrant, very powerful common law writ of habeas corpus.
Yeah, and this is mostly news to me, even though I practiced law in New York for many years. But all of the habeas corpus cases I ever saw were, prisoners who were bringing it under statutory provisions. So I kind of had no idea of the expansive nature of habeas corpus and the expansive nature of what the common law can do. Why do you feel so strongly that the common law is crucial to legal progress for animals?
Well, a judge can base a decision on the common law, which is the law that judges make, or on some written document that someone other than a court made. For example, an international treaty, a constitution, a statute. But the fundamental difference between using the common law and using anything else is that when you use the common law, you are using the kind of law that is evolved by judges. And so judges can make the common law, and so judges can change the common law. When you're using statutes or constitutions, you're asking the judge to interpret something that someone else wrote. So the judge might feel that as a matter of justice, we ought to be able to use the writ of habeas corpus for a chimpanzee, but we'll look at a statute or the Constitution and say that's not what the drafters intended, and so will not rule in your favor. The good thing, though, about the common law is that if we can persuade the court that as a matter of justice, of new experience, of evolving morality, of changing scientific facts, that an old common law ought to be changed into a new common law, well, you've come to the right place, because the judges, are the very people who can do that.
Yeah, it really brings you back to concepts that one learned in law school, but that legal practice doesn't really bring you to very often. So it's really fascinating to think about all of this from a jurisprudential point of view. But let's get down to the actual cases, which have to do with real animals, which is more fascinating. So let's talk a bit about what the courts have had to say about your petitions. The statutory provision defining habeas corpus in New York specifically does adopt the common law, as you said, but in doing so, it uses the word person. In the Tommy case, the appellate division sort of acknowledged that the word person could be expanded, but held that the reason it could not be expanded to include animals was because they cannot bear legal duties in exchange for legal rights. Can you comment on that portion of the decision?
Sure. Now, the New York statute, which is Article 70, that regulates the use of the common law, really does just that. It's a procedural statute that regulates the use of the substantive common law. And so one of the many issues that we had to deal with was what the word person meant in Article 70. Did person refer to the way person is used in the substantive common law, or were they trying to narrow the word person through Article 70 to make it, or could it be more narrow than the common law? So one of the things we first had to argue was that the word person in Article 70 is identical to the word person, however the common law would use it. And if the court expands person within the meaning of the substantive common law, then it automatically is expanded under Article 70 within the meaning of the procedural part. So we did run into that problem in the third department. They did rule against us on that ground. We had a really, we obviously did disagree with that, that there is law in New York that talks about what personhood means, how you determine personhood, and that statute, that case goes back to 1972, and it involves the question as to whether a New York statute that allows abortion, whether or not that is constitutional. And as part of that, they look at the question of whether a fetus is a person. And a fetus, they said, was indeed human, but they ultimately held that a fetus was, while human, was not a person, which actually we think is really good for us, because one of the problems we often have, and we try to deal with proactively, is to persuade the courts from the get-go that person and human are not synonymous. And we spend a lot of time right up front showing the court that there have been many, many times in history in which many humans were not persons, and there are many non-human entities who were indeed have been and are persons now. And so what this court did was say that the question as to whether someone was a person it's not a biological question. And they said, they used the word biological. It's not a biological question. It's a matter of public policy. And so one of our complaints about the way the Tommy court dealt with the case, and which is the center of our current request to the Court of Appeals to take further appellate review, is that the Intermediate Appellate Court was not really following that Court of Appeals case. That it was in essence saying that only human beings could be persons, and that when it held that you had to be able to not only be able to have rights, but also accept duties, it was not following that New York Court of Appeals case. The Court of Appeals case said that all you had to do really was be able to have rights. It said nothing when it defined persons about having the capacity to accept duties. Obviously, if it did, that would have been the end of the fetus question immediately, because a fetus obviously cannot accept duties. It was saying the real issue is a matter of public policy. And so we argued to the court that, we argued for 90 pages of public policy, really, in our case. And the court really didn't get to the public policy argument, because they were, in essence, looking at a taxonomic question. And in their footnote, they had a footnote because they said you had to accept duties in order to be a person. But of course, anyone who walks down the street or has children understands that there are vast numbers of human beings in the state of New York and elsewhere who are persons but cannot accept duties. And the court then put a footnote in that, in essence, said, don't worry, this isn't going to apply to human beings. And we think that is not good law. It doesn't make any rational sense, and it also doesn't follow the teachings of the Court of Appeals.
Yeah, that footnote was particularly frustrating. It had to do with, correct me if I'm wrong, but because humans can collectively bear responsibilities, or because a lot of humans can, then it doesn't matter that some humans can't, which really doesn't make any sense at all. It almost seems like it was added as an afterthought when the court suddenly realized, or somebody on the bench realized, well, if we say you have to be able to accept duties, that's going to leave out all the children and mental incompetence and loads of others. So right. Particularly frustrating.
At that point, they really then backed away what they were trying to do, which is to make some kind of decision that didn't appear to be a taxonomic decision. But ultimately, it was a taxonomic decision. It was a biological decision. It said, hey, this is only going to apply to humans. And our argument is that ignores the teachings of the New York Court of Appeals, which says that personhood is not a biological question. It is a matter of public policy, and that the Intermediate Appellate Court, the Third Department, should have actually been grappling with our arguments about why, as a matter of public policy, Tommy ought to be a person for the purpose of a common law writ of habeas corpus.
Yeah, it does seem that there was a lot of dodging of the really hard issues in the decisions you've gotten so far. And I often wonder, too, whether it's possible to argue that animals do in some way bear a duty, that they bear the duty of being valid members of their own species. Isn't that what we value them for?
Interesting. Well, first of all, on our motion for a rehearing, which was denied, we pointed out that, although we weren't focusing on it because we did not think we would lose on this ground, that some of our expert witnesses really did point out that chimpanzees could bear duties, at least in chimpanzee society, and that they ignored that, and there were no expert witnesses who came in against us, and so there was no facts that supported their claim that chimpanzees could not bear duties. So. Of course, they just ignored us, but the fact is they could ignore us. But the fact is that it's true that there was no evidence that chimpanzees could not bear duties. There's some evidence then that they can. What we've done now is then appealed from their denial of our motion rehearing, and asked the Court of Appeals to take further review, and we hope it does, and that we can win. But if it doesn't, one of the things that we're seriously considering is going back to our experts, having them make clear that chimpanzees can shoulder duties, and refiling it right back in the same court that we filed the first case. One reason we think that there's some reasonable chance the Court of Appeals might take our case is that it's not only our arguments, but there have been 3 entities who filed what's called a letter brief, who have filed a letter brief to the Court of Appeals, saying in a summary way that the Third Department's decision was wrong, and that they urged the Court of Appeals to take our case, and they said they will then file full-scale amicus briefs. And that includes Professor Lawrence Tribe from Harvard Law School. It includes the Center for Constitutional Rights in New York City, and it includes Professor Justin Marceau from the University of Denver Law School, who is submitting a letter brief on behalf of a number of habeas corpus scholars.
Yeah, I mean, I really do. Of course, I hope very much that the Court of Appeals takes the case because I would like it to see it reversed, and also because we just need a more in-depth discussion, and because I think that the appellate division's decision is a little dangerous with this bare duties thing, that with this odd exception for humans that collectively, it doesn't. It's making the law of habeas corpus rather incoherent.
Yes.
But I'd like to also talk about the Kiko case, since we don't have...
Which is even more dangerous, frankly, and makes it even more incoherent.
Yeah, absolutely. It's a troubling decision. Now, in the Kiko case, maybe not as troubling from the same point of view, but the appellate division basically ducked all of the personhood questions to decide that the petition only sought a change in the conditions of confinement rather than to end the confinement itself. And that's not what habeas is meant to address. This was really ducking the issues as far as I mean, I've always said they're give me the ball judges and keep me out of it judges. And this was a keep me out of it like decision. Like they just ducked the issue. What was wrong with this decision from your point of view?
Well, let me see. How much time do we have? Well, first of all, you have to realize we actually we sought writs of habeas corpus in 3 Supreme Courts. Our first case, when we sued on behalf of Hercules and Leo, was tossed out on Long Island and went to the Second Department. The Second Department, sua sponte, threw our case out saying we didn't have a right to appeal.
Yeah, that's just ridiculous.
Well, and then the Third Department then decided Tommy's case. They did not throw us out. They simply ignored what the Second Department did, and they came out with what we consider to be a rather strange decision. Then we go to the Fourth Department. The Fourth Department ignores both what the Second Department did and what the Third Department did, doesn't even note that there's been any other cases that have been cited before it, and rules in a totally different way. So we've gone in front of 3 intermediate appellate courts. Each of them have ruled against us, each on different grounds, and each without acknowledging that another court in New York has also ruled on the case on a different ground.
Yeah, very strange. And I think some support for the idea that there's no obvious answer to your arguments.
I entirely agree. I think there is no obvious answer to our argument because I think our arguments are correct. But what the Fourth Department did was to say that asking for the release of Kiko and then asking then that Kiko be put into Save the Chimps or another sanctuary was not a proper use of the writ of habeas corpus, because you essentially have to be freed in an absolute way. Now, this indeed is the norm in that most habeas corpus petitioners are indeed adult human beings who, once they get the writ of habeas corpus, then they can simply walk out of their place of imprisonment. But we regaled the court with numerous cases involving, children and teenagers and mentally ill people, even a couple of them involving slave children, who had a kind of a double problem. They were both children and they were slaves, and showed that when the courts ordered them out released them on a common law writ of habeas corpus, they didn't make these 6-year-old slave children go out into the streets of New York City or a person who has Alzheimer's or something. What they did was they then ordered them into the custody of somebody else, which of course is the only rational thing to do. In fact, we addressed that at great length in our appellate brief to the Fourth Department. And if you look at the transcript, which we have actually posted on our website, at one point, the court raised this issue, and I was kind of so unrelenting in giving them example after example after example that finally one of the judges said, okay, we get it. So I stopped arguing it, and then I was more than a little surprised to see after one of the judges say, we get it, she then voted to have us, she joined the unanimous court in having us lose on that ground. And that case, the Fourth Department case, is a very dangerous case for the citizens of New York, because that means, that has an impact directly on every human being in the state of New York, that if they are a child, if they're a mentally ill person, if they have Alzheimer's or whatever, and they're being held captive, the Fourth Department, if that holds up, that would mean that you cannot no longer file a writ of habeas corpus on behalf of the human, and the child has to really stay imprisoned in someone's place until they're 18, or someone who has Alzheimer's or mentally ill has to stay in a grotesquely improper placement until they die. it makes no sense. And we think that we argued that in our petition to the Court of Appeals to take further appellate review, saying you need to look at it for chimpanzees, but you need to look at it also because it negatively affects every citizen of the state of New York, and it ignores numerous Court of Appeals cases and essentially is an outlier and attempts to overrule, dozens and dozens of New York habeas corpus cases that have come down over a period of 200 years.
Yeah, there's something deeply offensive about that decision, as if there's no difference between a prison and a confinement for the purpose of helping somebody, a mental hospital or a child custody situation. It's offensive, and I agree, it's very dangerous. Of course, as a result of these courts deciding the issues on these types of issues, neither of them reached your fundamental arguments, which, if I understand them correctly, address the definition of personhood under the common law and argue that personhood is rooted in the fundamental concepts of autonomy and equality. Do you agree that the courts basically avoided these arguments?
Yes.
So what do you make of that? Do you think they were afraid to get there?
Frankly, I'm not sure if they understand them. And I know they're very busy. And that's really one of my main concerns, that they simply haven't taken the time to really understand the arguments. And there was another kind of strange thing that happened, which is that both of our cases involving Tommy and Kiko in the Third and Fourth Department were originally brought under Article 70, where we ex parte sought an order to show cause. So that meant at the trial level there was no opponent, but there was an opponent then at the appellate level, but neither of the respondents either filed a brief or appeared in court. So both times, the Non-Human Rights Project was arguing without an opponent. And at first we thought, oh, great, there's not going to be another side. But I think as time went on, we became more concerned about that, thinking that perhaps what the judges are going to do is act like judges, but also partly act as advocates so they could try to fill in the missing advocacy role, and that the judges might end up confusing their role as advocates with their role as judges. And I think it's possible that something like that may have happened.
Having worked in a New York appellate court for most of my legal career, I can tell you that there's nothing worse than having a case that is only briefed on one side. And you do feel the need to bend over backwards to try to come up with what the other arguments would be, so you don't make a fool of yourself and issue a decision that's missing some obvious point. And here, when you're asking really to make a decision that is asking the court to really go out on a limb and will get a lot of publicity, it's putting the courts in a very difficult position to not have briefing from the other side, which means that your final case, the case involving Hercules and Leo, is probably, there's a lot of things going for this case. First, you have had opposition in this case, from what I understand. And also, I think you're clearly before give me the ball kind of judge.
Yes. Yeah, we were very happy about it. In fact, by the way, even if the Court of Appeals takes further review of either Tommy, Kiko's case or both, we're looking into the question of issue of asking the Court of Appeals to appoint to require somebody to come in and argue the other side, to appoint supplemental counsel, to order the counsel that they have to actually file a memo and show up, something like that. We don't quite know whether the court has the power or the inclination to do that. But I think that it would make perfect sense, and I think it would be doing the court a favor to have someone else on the other side. And frankly, we would like the most intelligent, advocate for the people who are imprisoning Tommy and Kiko as possible, because we're very confident about our arguments, and we would like to have a real kind of intellectual clash so that the judges can sit back and be judges and not be advocates.
So do you feel that happened in the Hercules? Well, tell us a little about Hercules and Leo, and about the hearing, and about whether you feel that happened in the Hercules and Leo case, that you had adequate opposition.
Well, we were delighted to have Stony Brook come in as a...
Now, that's Stony Brook University, right? Which University, is a New York State school that is where these chimps are undergoing experimentation.
Yes. So we sued the president of Stony Brook University, and we knew that the Assistant Attorney General of New York would come in, which I think it's important to know that they probably had a duty to come in and defend Stony Brook, so that we expected them to come in, and also we felt that the fact that the Assistant Attorney General was involved would actually focus media attention on them and the attention of other people as well. So we were delighted that happened. Hercules and Leo has been very interesting all the way through. The Non-Human Rights Project took many years of going through the law of all 50 states and 20 common law countries in order to determine which jurisdiction we wanted to file suit in first. We chose the state of New York for many reasons. Some of the many reasons focused on their really broad and embracing use of the common law writ of habeas corpus. At least on paper, it looks like they value it enormously. And one of the many things that we liked about the way that the state of New York views the common law writ of habeas corpus is there's no such thing as res judicata. So each day that someone is imprisoned is seen as a whole new cause of action. So we can keep coming in again and again and again, and we felt that, hey, everything about this is novel. And so the odds of us screwing up, or getting a case dismissed on procedural grounds we hadn't anticipated, were reasonable. So we wanted to go into a jurisdiction where we could then try to fix it by refiling it after we were thrown out. Also, the statute, the procedural statute, allows you to bring a habeas corpus writ before any judge, or not a Supreme Court judge, but really any justice. So that allowed us to refile in a whole different place, even after we lost. So when the judge in Riverhead on Long Island threw our case out, we didn't even have a hearing like we did in the other cases. I wouldn't know what he looked like if he ran me over. He just kind of came in and came out. He said, "No, get out of here."
He kind of did run you over.
Yes. I must have been looking the other way, and then the second department then just sua sponte said, "Hey, you're not allowed to appeal," which we knew was wrong, but we also filed a motion for rehearing in front of them, and they affirmed themselves, and they also said, we deny without even asking. They said, we deny any motion for leave to appeal to the Court of Appeals. So we decided that instead of appealing to the Court of Appeals, which would set us back a long time and get us involved in all kinds of procedural issues that were not really germane to the underlying cases, that we would invoke the Article 70 procedural statute and just simply refile the case, but in another department. So we'd already been in the second department. We already had cases going in the third or fourth. So it didn't take much math to figure out that we had not yet filed a suit in the first department. Let's give the first department a chance to weigh in. Plus it was Manhattan. There's a chance that the urban judges might think differently than the three rural judges, with that three sets of rural judges essentially that we had. And so we filed suit there, and by chance it was assigned to Judge Barbara Jaffe. And she indeed then did what we were asking, and which made us very happy. There was one thing that we did actually. I have to admit that I was rather embarrassed, and I continue to be embarrassed, which is why I'm confessing here, as I've confessed to my students and others. I wrote a book about the famous Somerset versus Stewart case, in where a black slave had used the common law writ of habeas corpus in London in 1772. And I'd spent 3 years really studying that case and writing a book about it, because I intended it for it to be a blueprint for the work of the Non-Human Rights Project. And I had understood what Lord Mansfield was going through when he accepted James Somerset's case. And in order to have a writ of habeas corpus issue, you have to be a person. Writs of habeas corpus may only be issued on behalf of persons, but not things. So what do you have when a black slave like James Somerset comes before Lord Mansfield and says, issue me a common law writ of habeas corpus? If Lord Mansfield thinks he's a thing, he's not going to do it. If he thinks he's a person, he will. But it's not clear whether he is or whether he isn't. So I concluded that Lord Mansfield had thought, well, I'm not sure what he is. I think he might just be a person. And so I'm going to issue the writ of habeas corpus, and we'll have hearings to determine whether he actually is a person. So in our petition for habeas corpus that went to Judge Jaffe, on the very first page of it, we had specifically discussed this and asked her to issue the writ of habeas corpus, not just as she thought Hercules and Leo were persons, but as she thought, like Lord Mansfield did, that perhaps they could be persons. So we also, we asked for a writ of habeas corpus, but we also asked for an order to show cause, because what we really wanted, was an order to show cause, because in New York, a writ of habeas corpus requires the respondent both to come into court and give a reasonably and give a legal explanation for detaining the person, but they also have to bring the prisoner into court. An order to show cause means that you just have to come in and give a legally sufficient reason, but you don't bring the prisoner into court. So we did not want Hercules and Leos to be brought into court, but we had been thrown out by the Second Department the last time we'd asked for an order to show cause. So we decided to ask for an order to show cause and a writ of habeas corpus. So she indeed issued a writ of habeas corpus and an order to show cause, as we asked, even though they were mutually contradictory, in that the order to show cause said, don't bring the prisoners in, and the writ of habeas corpus said, do bring the prisoners in. So we, as lawyers, good lawyers, we were trying to cover all of our bases. So we issued a press release saying that by issuing the writ of habeas corpus, Judge Jaffe had implicitly found that Hercules and Leo were persons, frankly, forgetting that we had asked her that we had said, please do it even if you don't think that they're persons, and that you could, however, feel that they might be persons. So after we realized our mistake, and I was kind of horrified when I went back and realized that Judge Jaffe had done what we asked her to do, and we had then misconstrued it accidentally, we then went back and filed a second and sent out a second press release saying, no, we haven't. She hasn't decided they are persons, but we think that she's decided that there are some circumstances, apparently, that could persuade her that Hercules and Leo could be persons. Meanwhile, she took back the habeas corpus part. She filed a new order crossing out the habeas corpus part, which was perfectly fine for us, because we never wanted a writ of habeas corpus in the first place, just an order.
So she basically did what Judge Mansfield did.
Yes.
It just got, when you're doing cutting edge work, it's confusing. And then when the press picks up on it and makes everybody oversimplifies things, it can get very complicated. But basically, what you got was your hearing.
Yes, that's what we wanted. And she began the hearing by really kind of chastising us for what had happened, which, I took it as meaning, okay, I deserved that. But then she simply immediately put it behind her. And you could see she had been thinking about this at great length. And in fact, she had a number of questions that she appeared to have written out that she used to inquire of the Assistant Attorney General, why shouldn't be doing this? And she seemed to be very open to the argument. She seemed not to have made a decision. She, inquired deeply of me. She inquired deeply of the other side. She was really just the kind of judge that we were hoping to draw.
Yeah, and maybe finally your real argument, the court will actually reach your real arguments as opposed to these let's get rid of this case kind of arguments that the other courts reached. And my understanding is that a great deal of your case is based on science demonstrating that chimpanzees have autonomy. And can you just give us your shorthand definition of that term, since it is kind of the basis of why they should be entitled to habeas corpus?
Well, autonomy, or an autonomous being, is essentially a being who does not act by only by instinct or some other kind of learning. That there's some kind of black box in their mind that mediates the whole exercise, so that they actually are thinking about things, they're planning things. They're not acting by instinct. It's really a hallmark of great intellectual flexibility. And the reason we cared about that is that our reading of the New York decisions, which we talked about in court, made it clear that the New York courts have been extraordinarily concerned about autonomy and view it really as one of their supreme, if not the supreme, common law value. And we pointed out to the court that in the state of New York now, in light of New York case law, that if an autonomous, if say an adult goes into a hospital and turns away life-saving surgery or medication, the Court of Appeals will allow them to do that. They won't interfere, and they respect the autonomy of that person so much that they will allow that person to die. In other words, we respect your autonomy more than we value your life, and that is a very powerful statement. And so we then show that these chimpanzees have autonomy, certainly to the degree that they can make decisions as to whether or not they want to be imprisoned or they don't want to be imprisoned, or they want to live with other chimpanzees or they don't want to live with other chimpanzees, or they want to live the life of a chimpanzee or they don't. And so, we filed 100 pages of scientific affidavits from 9 experts from across the world in Japan, Sweden, Germany, England, Scotland, and the United States, who made it clear that chimpanzees are extraordinarily cognitively complex beings, and that individually or together, these 40-plus advanced cognitive capabilities make it clear that they are indeed autonomous beings.
Yeah, and my understanding is as well that you're not saying that you necessarily have to have this extraordinary level of autonomy as chimpanzees have in order to be entitled to the writ. But it's certainly obvious that if you have this level, you are entitled.
We argue that the degree of autonomy we're talking about is a sufficient condition in New York for a writ of habeas corpus. We don't argue it's a necessary. It's a necessary condition. We're kind of agnostic on what the necessary conditions are.
I think that's an excellent point, because many people have thought that these arguments might leave other animals behind, and they could even leave some humans behind, clearly, who do not have this level of autonomy. But your arguments do not do that. They simply say they're simply arguing about chimpanzees.
There is a lot of misunderstanding everywhere as to what we argue, but that is one way. Maybe perhaps I can help clear it up. Is that we're not arguing that this level of autonomy is a necessary condition. We're arguing that it is only a sufficient condition, but that it is. We pass it, that the chimpanzees have what it takes.
Yeah, clearly. Let's talk a little bit about equality as well, which is the other common law principle you have evoked in these cases. If I understand correctly, your position is that while constitutional principles of equality, which is what most of us are familiar with, focus on whether a particular type of discrimination is irrational, common law principles of equality focus on whether discrimination is simply wrong in a moral sense, or unwise or inappropriate. Am I stating that correctly? And if so, what are the implications for these cases?
There is a common law of equality, but after the 14th Amendment came in, people really stopped litigating common law equality all across the United States. And it's very hard to find a common law equality case, anywhere. There are a few in New York. We have them. They're mostly involving public utilities, the duty of public utilities to treat people equally. But we seized on something which I think is true. A law review article that former Chief Justice Kaye wrote about 10 years or 20 years ago, in which she talked about the courts have been bringing in these constitutional ideas of equality into the common law. They've been really constitutionalizing the common law. And that makes perfect sense to us, because the common law of equality hasn't evolved in the last 150 years because nobody files suits under it. So we brought that in and said, look, although we're not claiming that the chimpanzees are persons entitled to equal protection under the 14th Amendment, we think that the court, when they're deciding what equality means under the common law, would be good to look at how equal protection jurisprudence has evolved. So we argue that anybody is can make classifications. Courts classify all the time. Legislatures classify like every single day. However, one of the things that's required, it is really like a minimum rationale, that in order to have a classification not run afoul of the rule requiring equality, it really has to be a rational means to a legitimate end. That's what I was arguing in front of Judge Jaffe, and we're saying we're not even talking about about rational means. We're simply saying that cabining off chimpanzees from the use of a common law writ of habeas corpus just because they're chimpanzees, it's not rational for one thing, but it allows them to essentially to be enslaved, to continue to be things, and it's really an illegitimate end that for the state to endorse the enslavement of autonomous beings is not a legitimate end, and therefore it should violate common law equality in the state of New York.
I kind of get chills just listening to these arguments. I think they're so powerful. And I know you're going to be continuing to preparing cases on other animals, and I believe you'll be moving beyond chimpanzees to other types of animals. Will you continue to use habeas corpus as your legal argument?
Yes, we're preparing an elephant suit now in another state, and right now we are going to continue to use habeas corpus. We have a bunch of other causes of action that we've also been developing over the years, but right now we really like habeas corpus, and we'd like to continue trying to flesh it out. And of course, the more success we have, the more we're going to use it. There are states who may not be as favorable to us on habeas corpus as the state of New York is. For example, you look at many of the southern states and also some of the other states. They have a long history of saying when a slave in the antebellum South sought a writ of habeas corpus, they refused it. And so we're not sure whether those are fertile grounds for us using a writ of habeas corpus or not 150 years later. They may be, they may not, but we're developing other kinds of causes of action, and we're even writing about them. In fact, because there's so little, in fact, there's nothing really written about many of the ideas we have, we're beginning to write our own law review articles and try to get law reviews to place them. So one example is the ancient doctrine of manumission, which began in Roman times, which allows a private entity to free a private person, human, to free his own slave. And we're looking at that, and it was used in the United States up until the Civil War. There were many states who had slavery. They allowed slaves to be manumitted. And so we're looking into the question as to whether or not someone who privately owns, say, a chimpanzee or an elephant or some other non-human animal could privately manumit that non-human animal and thereby bestow personhood on her privately. And so it may not surprise anyone, there were no articles that were written about manumission. And so we actually wrote one, and it was actually published this year in the George Mason Civil Rights Law Journal. So we like that for two reasons. One, we get the ideas of manumission out to the public, and it's also being published in the Civil Rights Law Journal because the Non-Human Rights Project, in fact, I think we just changed our website. We describe ourselves not as an animal rights organization, but as a civil rights organization who's focusing on the rights of non-human animals. So we're pleased that our articles appearing in a civil rights journal.
Yeah, it's fascinating. And it really brings us right back to what we were talking about at the beginning of this conversation, that it's not just from the substance for the animals that makes these cases so interesting. They're just so fascinating from a jurisprudential point of view. And it really kind of brings you back to law school, only it's a lot more entertaining than law school was.
When we bring on volunteers, we have to sit down and warn them, you're not going to read any articles about, you're not going to be reading cases about animals. You're going to be, we have to introduce you to the 18th and 17th century English reports and, learn how to read those. And really, you're going to be working on jurisprudence that's really kind of scraped down to the bottom levels, to the foundational ideas that construct jurisprudence. And so you're not going to be interpreting statutes. You're going to be trying to understand the basic ideas that underlie our most powerful jurisprudential and other ideas of justice. And so be prepared to do that rather than try to understand what a statute means.
Yeah, it's no wonder you're getting some weird decisions from the courts, because this isn't really what they're used to doing. And and you're getting a lot of attention from the press as well, much like kind of unbelievable amount of attention from the press that I think's been pretty positive. Are you pleased with it?
We are ecstatic. We went in feeling that we were really drawing a target on us and on ourselves, and we were going to get pummeled after we filed our first cases. To our surprise, that has not happened at all. We think, for one thing, maybe this time has come. We also spent many, many, many months, going over our affidavits, going over our memoranda, going over our petitions. So when we write, we actually write not just for the judge, but we're also really writing for history. We understand that this is the first time it's done. We're writing for history. We're writing for law schools. We're writing for other judges, and we're also writing for the judge before whom we are appearing. So we try to make it as powerful and well-written and error-free writings as we possibly can. And we try to make them as persuasive as we possibly can. We literally have 4 or 5 of us sit in a room and go over every single sentence and argue about anything that might pop up. And it takes us days, even to do that. And so we have seen, for example, when we filed our first case on CNN, there was a legal panel on CNN talking about it. And the lawyers there said, we thought that it was a really stupid idea. Then we started reading their papers and we think, wait, hey, this is not a bad idea at all. And that's exactly the reaction that we're hoping for. And we think those people who take the time to look at what we're saying realize that we are in earnest, that we have invoked, fundamental principles of Western law in our support. And then we think these fundamental principles of Western law do support us. And the only way that we can lose is for the judges to try to figure out how to get around those fundamental values of Western law. And so I think is one thing that really explains really the positive, or at least it goes a long way towards it, explaining the positive reaction we've had in so much of the press. There's also other things too. It's not just the press in general, but we have been getting positive articles in science journals. I just gave a speech at the Art Institute at Hunter College, and I was sitting down talking to these 2 art curators, and asking, why did you invite me there? And they were telling me why the work of the Non-Human Rights Project has been influencing their work as artists and curators. I had the artist who was in charge of the Greek exhibit at the Venice Biennale for 2015, interviewed me, and our interview is in the catalog. I just gave an interview to an international aesthetics magazine. I wrote an article for Foreign Policy magazine. We are kind of going deep into psyches that we thought would not pay attention to us.
Yeah, it really is fascinating. It's like you're giving people permission to think things that they haven't allowed themselves to think before. And I know everyone listening is going to want to stay on top of your work. Just tell us how people can stay on top of the work of the Non-Human Rights Project online. Sure.
Our URL is nonhumanrights.org. We put everything online, whether it's good or bad. Every document that is filed in court, either for us, against us, the judicial decisions. We have the transcript of all of our hearings. Everything goes up on our website. And then as things come down, we also put them up on our Facebook page. So we have a very active Facebook page. But if you really want to get into the nitty gritty and read, complex briefs, complex decisions, transcripts, just go to nonhumanrights.org and click on the case you're interested in looking at.
Yeah, I really recommend that people do that. And we're going to have to cut this off because I'm going to get in trouble because we went over the amount of time I was supposed to spend. But I could talk for hours more. Thank you so much for joining us today, Stephen, especially for our first episode.
Thank you for asking.
Thank you so much for joining us today on the Animal Law Podcast. The Animal Law Podcast is part of the Our Hen House podcast family, and you can also listen to our signature weekly Our Hen House podcast. You can find it on iTunes or Stitcher or on ourhenhouse.org. There are nearly 300 episodes already recorded, so you've got your work cut out for you. As a 501c3, Our Hen House relies on your contributions to keep our work going and to keep vegan indie media alive. So we hope you'll support us by becoming a Flock member. It's $15 a month or $150 a year. And if you do, we'll send you a tote bag and exclusive login info. And that will give you access to exclusive content, giveaways, and it will also give you access to the vibrant, private Our Hen House Facebook group where people are having the most interesting, fascinating discussions every single day. You can go to ourhenhouse.org and click on Donate. Follow us, please, on Facebook and Twitter at Our Hen House, and you can contact us by clicking on Contact at ourhenhouse.org or just by emailing us at info@ourhenhouse.org. I'm Marianne Sullivan. Thank you so much for being here today. So long.